issue that we are hearing a lot recently. But the reason I'm making this video is that this is not law yet. First of all, as you know, there are a bunch of propositions under the executive power, and it's under the OMB. And I will put the link down where on this YouTube video about this. So I wanted to make this video especially because a lot of people are asking me the questions: when do they get their I-140 EAD? um, but the answer is we don't know yet, because this is still being proposed. Actually, there are two rules of the EAD that is being proposed. For one, there's one which is going on public comments up to February 29. That one is basically talking mostly about maintaining the priority date and not allowing to revoke the I-140. And there's another one which has been sitting there for a while, is the EAD. A lot of people made noise about it. I myself was very happy that it might come true, but so far we have not seen it going on the right direction. So until then, I will recommend people caution not to rely too much on that. And if another frequently asked question I have is, people confuse the AC21 rules with the I-140, which is also under AC21 rule, but the rule of 180 days. Many people think that they can have they as long as they leave after 180 days, the I-140 cannot be cancelled. Well, that's not really true. Unless this new law passes, the employer can revoke an I-140 anytime, and the USCIS can revoke it pretty much for any time. 180 days, the rule that applies only to those who are in the AC21 section, usually section 104C basically, which says if you have an I-45 adjustment of status filed and 180 days has passed, your I-140, your employer cannot revoke your I-140. You can still use it, and basically you can even transfer the entire case to another company, as long as you're moving to a same or similar position. And you can also basically, you have to have the 180 days rule then. However, having said that, this rule doesn't apply to cases where there's no no I-45 filed, and this mistaken belief has led many people to be confused on the rule and end up by creating problems for them. One of the biggest problem we've seen, without the I-140, if you have reached 6 years extension, you will not be able to move to another company if you want to transfer your H-1B. And when I'm saying moving, I'm not saying moving of the I-140, I'm talking about moving of the H-1B. Even though you think you have an extension for 3 years already granted with company A, for example, you will not be able to move it to company B. And that's major, because this confusion has made people mistakenly believe they could do so and end up by losing the H-1B. So be careful on that. And the same rule kind of apply for H-4 EAD. If you're transferring H-1B, the I-140 is being cancelled in the meantime before the EAD, the H-4 basically gets approved. The EAD also might be cancelled. So having said that, the video today is mainly to tell people that there's no I-140 EAD yet. Hopefully it will become law, so don't get fooled by people who are basically keep saying that it's there. And also, if you need help, right now is H-1B season. If you need help on H-1B or H-1B transfer or perm labor certification cases, and even an AC-21 letters where you transfer your entire case to another company, feel free to call us at 510-742-5887. Ladies and gentlemen, anything I told you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. Again, the number to our office, 510-742-5887. I have put the link for our website in there. Thank you. Keep listening and subscribe to our channel. Bye-bye.